This program is brought to you by Emory University.
Good morning, everyone. And I'm the Executive Symposium Editor of the Emory Law Journal. It's an honor to welcome you all today to the 34th Annual Randolph W. Thrower Symposium, which we have titled The New Age of Communication, Freedom of Speech in the 21st Century. This year's symposium focuses on a right that is fundamental to the very core of our society, the freedom of speech. The world today is a place of constant communication, big data, and shifting censorship, issues which shine a light on the very foundation of that right which we hold dear. Today's symposium aims to create a diverse dialogue to understand the journey of free speech, where we've come from in our theories, where we are now in the modern doctrine, and where we will go in the future of free speech. In order to achieve our lofty goals, we've asked some of the brightest and most interesting academics and practitioners from across the country to share their thoughts on free speech. Beginning with our keynote speaker, Professor Eugene Volokh, UCLA School of Law, and continuing throughout all of our panels, these speakers will explore the many facets of free speech debate with theories, examples, and illustrations that I know you will find both fascinating and illuminating. We hope that each of you will find the discussion thought-provoking, and that this event will simply be the starting point for continuing debate and reflection on the idea of free speech. Although I have the honor of kicking off our symposium today, we would not be here if not for the work of many individuals who I would like to recognize. First, I would like to recognize the Thrower family and the specific Thrower family members who are here with us today. Patricia Barmeyer, Wilson Barmeyer, David Bykoff, and Patricia Harris. We thank you for your constant support. I'd also like to thank the Thrower Committee for their ideas and support in the development of this year's symposium. Members include the Honorable Frank Hull, Joseph Blanco, John Mayu, Dean Robert Shapiro, Professor Julie Seaman, and Professor Charles Shaner. Thank you for helping to shape the ideas behind this symposium and making this event a reality. Through your help, we can continue to honor the legacy of Mr. Thrower, who I would like to think would be happy to see, hear, and join in our free speech discussions. Members of the Emory Law faculty and administration have also proven instrumental in putting together this year's symposium. We owe thanks to Professor Sasha Volokh, Richard Freer, and Vice Dean Robert Adier, as well as Amy Tozer, Eric Johnson, Alyssa Ashdown, and all the other administrators that make this event possible. I would also like to thank my symposium editor, Roxanne Walton, as well as the 2L staff members of the journal for their help and assistance in putting this symposium together. These students come together to help me make this event truly shine, and I hope you all will have the opportunity to meet and talk with them as today progresses. Additionally, I would like to thank Professor Alexander Cesis for his help in creating the symposium. Professor Cesis has been an invaluable help to us in creating and crafting the free speech dialogue that we'll have today. He's worked with us from the start to make this year's Thrower Symposium a truly special one. We are honored to work with you, and thank you so much for all you have done. Last, but certainly not least, I would like to thank Ben Klebanov, Editor-in-Chief of the Emory Law Journal. You know, it's funny, when I was elected to this position, the first person to come up to me and congratulate me was Ben. And he told me that moment that this was going to be the best symposium ever. Now, for those of you who have ever met and worked with Ben, he expects that of pretty much everything that he does. And I'm hoping, and I do truly believe, that we've delivered on that idea. Thank you very much for your help, Ben. And on that note, it is my privilege to introduce Benjamin Klebanov, the Editor-in-Chief of the Emory Law Journal. Ben is a 2009 graduate of Oberlin College, and he's worn many hats at the law school, which make us all wonder at what point in time he actually leaves. Ben has written multiple briefs for the Emory Law School Supreme Court Advocacy Project, as well as working for individuals throughout our community as a student volunteer in the Volunteer Clinic for Veterans. Ladies and gentlemen, Mr. Benjamin Klebanov.
Good morning. Thanks, Gerard. Please allow me to echo Gerard's welcome to all of you to the 34th Annual Thrower Symposium. We are truly pleased to present this year's symposium, The New Age of Communication, Freedom of Speech in the 21st Century, which will explore the future of free speech doctrine and jurisprudence. The essence of free speech is captured not only in the words we use, but also in our public actions. Whether it is putting on a jacket emblazoned with one's views of the draft, carrying a poster, or engaging in a vigorous debate, the essential nature of speech to our everyday lives is what perhaps always draws our focus to the latest actions taken by government officials and others who push and mold what forms of speech are deemed acceptable. As members of the legal profession, we have a special interest in protecting individual rights and liberties under the First Amendment and the maintenance of principles which often run counter to majoritarian views. So said Randolph Thrower in the amicus brief he co-authored on behalf of the American Bar Association in United States versus Eichmann, advocating for the appellee in the case which affirmed that a person's decision to burn a flag is constitutionally protected. His words, of course, remain true today. Words are powerful. Whoever promoted the phrase, "Sticks and stones may break my bones, but words will never hurt me," clearly had no idea what they were talking about. It is with that in mind that I ask, as we move forward with today's symposium, that we all, as panelists, moderators, and as an audience, remain mindful of the impact our words can have, even if these impacts are not immediately foreseeable. I look forward to what I know will be a fascinating presentation regarding the status and future of free speech. In accord with our long-standing tradition, the discussions, debates, and ideas presented here today will be memorialized in published form in the Thrower Symposium issue of the next volume of the Emory Law Journal. This event would indeed not be possible without the efforts of many of whom Gerard has already mentioned, but I would be remiss if I did not name a few more and echo a few additional words of thanks. First, to Gerard Berfocco, our executive symposium editor, who is a great friend and colleague, and whose efforts and mastery of logistics has allowed this day to fully come to fruition. Second, to Roxanne Walton, our symposium editor, whose efforts to make sure we thought through all of the necessary logistical steps, and whose assistance has made this event a truly seamless affair. Third, to the members of the Thrower Committee, and of course the Thrower family, whose support and enthusiasm for this event allowed this day to actually be possible. We are truly honored to be able to host this event and to carry on this legacy which you have entrusted us. Fourth, to Professor Alex Sessis, whose ideas and passion for this topic shape the course of what we will present to you all today, and who is eager to seriously consider our thoughts as we plan this day. We are very humbled to have had this opportunity to work with you. And finally, to the staff and board of the Emory Law Journal, with a special note of thanks to my friends on the executive board, who I have the distinct privilege to work with. All of your efforts allow our journal to host great events like this and publish excellent work. It is now my honor to introduce Dean Robert Shapiro. Dean Shapiro is the 11th Dean of the Emory University School of Law and has tirelessly supported the symposium and the Emory Law Journal. Dean Shapiro is Asa Griggs Candler Professor of Law and teaches federal courts, constitutional law, and civil procedure. Dean Shapiro earned his BA from Yale, a master's degree from Stanford, and his JD from Yale Law School, where he was the editor-in-chief of the Yale Law Journal. He clerked for Judge Pierre Laval, then of the Southern District of New York, and Justice John Paul Stevens of the United States Supreme Court. He then worked with the law firm of Sidley & Austin in Washington, D.C., where he practiced general and appellate litigation and taught for 2 years at the Duke Law School before joining the Emory faculty. Please join me in welcoming Dean Shapiro.
Well, good morning. I'd like to welcome all of you to this 34th Annual Thrower Symposium. Academic years have highlights, and at Emory Law School, the Thrower Symposium is one of the shimmering highlights in our intellectual calendar. Now, at Emory Law School, we seek to advance the rule of law and promote positive social transformation through the students we educate, the ideas we create, the service we perform. Now, this symposium has been generously endowed by the family of Randolph W. Thrower, and Mr. Thrower, who graduated from Emory Law School in 1936, was indeed a shining exemplar of these ideals of the law school. He devoted his life to service in the private and the public realm, including serving as Commissioner of Internal Revenue from 1969 to 1971, where he scrupulously guarded the independence and integrity of that powerful organization and stood as a courageous bulwark against political pressures. Now, this is the first symposium we've had since Mr. Thrower passed away last March at the age of 100. In the 33 prior symposia, he was a regular attendee. His absence is keenly felt today, and yet this symposium stands as a lasting tribute to him. I'll note it's really one of many elements of his enduring legacy. Just Tuesday of this week, in this auditorium, the Emory Public Interest Committee hosted its Epic Inspiration Awards, and in the course of that award ceremony, Mr. Thrower's name came up again and again, particularly with regard to his role in saving Atlanta legal aid when it was really faced with extinction. And it was his personal effort that allowed that important organization to survive and to thrive until this day. We're also very grateful for the members of his family who are here. Your continuing presence is an important sign of support, which we very much appreciate. And I would commend to you last year's edition of the Thrower Symposium issue of the Emory Law Journal, which just recently came out and contains several tributes and remembrances of that great man. Now, the Thrower Symposium is a fitting realization of the vision of Randolph Thrower. This symposium brings together leading scholars, practitioners, judges, law students, and interested citizens to consider important issues of great current significance with lasting long-term implications. Recent topics have included privatization, civil adjudication, the politicization of the judiciary, innovation in the new age, federalism, executive power. And this year's symposium on the new age of communication, the freedom of speech in the 21st century, continues that wonderful tradition. In a moment, we're going to have a sterling introductory keynote talk by Professor Eugene Volokh, followed by a number of panels considering the foundations and current concerns related to the First Amendment and freedom of speech. We'll have leading scholars and practitioners considering these cutting-edge issues of doctrine, of theory, of practice. You don't have to be a constitutional law professor like I am to know that it's going to be a great day and that there's going to be much to look forward to. Now, when we consider the freedom of speech, we think about things like the rule of law. Right? The rule of law requires the free flow of ideas, of opinion. We think of free speech as the very cornerstone of a free society, as essential to a democratic form of government. Now, the new age of mass communication has expanded the possibilities for the broad dissemination of ideas of all kinds. New forms of communication have led to new freedom, new possibilities for an explosion of unmediated, unfiltered voices. These days, you don't need to own a newspaper, a printing press, or even a copy machine to have your views widely distributed, although having a lot of money does help to greatly amplify your views. Of course, when we think about these possibilities, we also think about the challenges that freedom of speech presents to us. Speech can be liberating. It can be empowering. It can be illuminating. And speech can be hurtful, degrading, blasphemous, malicious. Speech can invade privacy, dignity, can threaten national security. We think about all of these challenges that free speech presents to us today. Well, when we think then about what all the possibilities are to look forward to over the course of today, we know it is going, in fact, to be a very exciting exploration. And we think about the ability to look at issues of the rule of law, of freedom, of democracy, in some of the most compelling and important kinds of implications. So I said speech can indeed be potentially harmful. It can be harmful to individuals. It can be harmful to communities. and we know that speech can lead to harm to the speakers themselves. And the recent tragedy in Paris just reminds us of the seriousness of the topic that we confront today. And I'd certainly like to thank all of those who have made this symposium possible, and I'd just like to single out, of course, the Thrower family, the organizing committee for the Thrower Symposium, and the outstanding students of the Emory Law Journal who make all of this possible, and in particular, the editor-in-chief of the Emory Law Journal, Ben Klebanov, and the executive symposium editor, Eugene Volokh. And now I'd like to turn to introducing our keynote speaker, who's going to start off our events for the day. Professor Eugene Volokh received his BS degree in math and computer science from UCLA at the age of 15, which then allowed him to spend 12 years being a computer programmer before he returned to UCLA Law School at still a relatively young age. Following graduation from law school, Professor Volokh clerked for Judge Alex Kaczynski on the United States Court of Appeals for the Ninth Circuit, and then for Justice Sandra Day O'Connor on the United States Supreme Court, before he returned to the faculty of UCLA Law School, where he is the Gary T. Schwartz Professor of Law, and his courses include a First Amendment amicus brief clinic, and Professor Volokh has indeed litigated in courts around the country. In 2002, he, along with our colleague, Professor Sasha Volokh, founded the Volokh Conspiracy blog, which he recently formed a joint partnership with the Washington Post. That blog receives between 35 and 40,000 page views a day and is one of the most influential and widely followed blogs. In addition, Professor Volokh has published numerous textbooks, including textbooks on the First Amendment, the religion clauses, and on academic legal writing. He has published more than 75 articles in academic journals and at least that many op-eds. He is truly a public intellectual in addition to being one of the nation's leading authorities on constitutional law with a particular focus on the First Amendment and the freedom of speech. He is widely cited, extremely influential, and it's my pleasure to introduce him today as our keynote speaker. Please join me in welcoming Professor Volokh.
Thank you very much for a very kind introduction. Thanks for having me here. Thanks for letting me speak about this topic, which is something that is of great interest to me. I've been trying to follow the effect of the internet on First Amendment law and law more broadly since there was an internet. As I'd mentioned, I was a computer programmer in the 80s. Actually, I never much used the proto-internet of the time, ARPANET and eventually Usenet and such, but I had lots of friends in the computer field who did. Some of them were involved in some of the underlying technology. And the funny thing is, I remember after the internet really surged on the stage, it was around 93, 94, when people, instead of having a few people have these email addresses, you may remember them, some of you weren't born, but you may remember some of them, the octal numbers, the CompuServe.com. You couldn't get your name. You had to have like a several-digit number. All the digits were 0 to 7 because it was an octal address. So there was the stuff out there, but it really exploded in around 93, 94, and then just continued to become so much more significant ever since. I asked them, well, did you expect this to happen? And almost all of them, computer professionals, said they didn't. That what had happened technologically was this interesting confluence of higher modem speeds, computer monitors that were able to render graphics in an effective way, development of software that took advantage of all of that, and a development of higher processing power. Things that people saw were all happening, but they didn't realize that at some point when they converged, this computer, which remember comes from compute. That's what they used to be for in the 40s and 50s when they were developed, which had become a data processor. By the time I was working, it was mostly not for scientific computation applications, but for data processing, would become a communicator, would become our main device for both commercial communication, but also for communication of information. And communication of facts, communication of opinions. It was really a striking technological change that had quite profound effects. Now, it turns out the profound effects have not been in the area of changing First Amendment doctrine. By and large, Supreme Court tends to treat communications as largely medium independent. There are all sorts of exceptions, but it's been largely so. And for reasons which I'll get to in a moment, the court has deliberately chosen to treat the internet communications much like it has historically treated books and the like. So I'm not going to talk about the way the internet has changed First Amendment doctrine because I don't think it has done that much. It's changed business tremendously. But what it has changed is it's changed in some measure the shape of First Amendment disputes that we're having. There are all sorts of disputes that we're having today that while possible before the internet, were very much less likely. And that's what I'm going to try to explore a little bit in the coming minutes. So cheap speech and what it has done. So what do I mean by cheap speech? Well, oops, I'm sorry, wrong button. How about this? So this is a quote from A.J. Liebling, who was a journalist and a political, I guess, media commentator in the 60s. It's a famous quote says, "Freedom of the press is guaranteed only to those who own one." And that was the broad understanding of one kind of critique of freedom of the press. It was actually a critique that didn't have that much of a constructive dimension. It was sort of a regretful critique rather than, and therefore we should radically change it because radical change wasn't seen as being on the horizon. But it was, I think, an apt critique. Others had made the same point. So, for example, this is from Cass Sunstein in Democracy and the Problem of Free Speech in 1993, right before the internet surged. Broadcasting acts as the practical equivalent of right to speak, and it's allocated very much on the basis of private willingness to pay. The message is, look, people talk all of these things about freedom of the press. They talk about this glorious thing, but it turns out it actually belongs to only a few people. It belongs to those who are rich enough to own printing presses and those whom they allow to use those printing presses. Jerome Barron had said it earlier in 1967 as actually part of an attempt to change the law to provide for access to the press for the public. An attempt that was then pretty quickly batted down, except as to broadcasting, where it had always been the case. But it was batted down in Miami Herald versus Tornillo unanimously in 1974. But the animating principle was the same one we saw in Liebling quote, which is that comparatively few private hands are in a position to determine not only the content of information, but its very availability. Finally, Owen Fiss, Free Speech and Social Structure, an unregulated marketplace of ideas will include only those that are advocated by the rich, by those who can borrow from others, or those who could put together a product that will attract sufficient advertisers or subscribers. So this is a critique of freedom of the press, that freedom of the press does not live up to its rhetoric, not because the court has underprotected at least freedom from the government, but because the reality of the press, this technology, was it was very expensive to deploy. Not just because printing presses were expensive, although the really good ones were, but because the communications infrastructure, the trucks, the truck drivers, the news racks, all of those things were extremely expensive. Even setting aside news gathering, even if all you were doing is providing opinion, that was something that was often prohibitively expensive for all but a favored few, who were the ones who enjoyed the freedom of the press and those who didn't. And the interesting thing in many ways about the internet is it has essentially brought the reality of communication closer, not by any means a perfect match, but closer to the rhetoric of freedom of the press than it had been when that rhetoric was developed. And it comes from basically three things. The internet allows communication at a much lower cost. That means lower cost to the speaker. It means lower cost to the recipients. Still, you sometimes have to pay money for information online. It is shocking how much information is available online for free. I think that's another thing people would not have predicted in 1990, that, yeah, an army of people would produce a relatively reliable online encyclopedia with no compensation whatsoever. And not only that, but the publishers of dictionaries and many kinds of encyclopedias will also put them online with no compensation except for the modest amount they will get to advertising. People would have been very surprised. I was very surprised. That has in large measure happened. Relatedly is convenience. It is easier than ever before to read things. You don't have to go to the bookstore. You don't have to rummage around, or excuse me, let's say go to the newsstand. You don't have to rummage around town to try to find the right newsstand. It all comes to you in your home. Now, convenience may seem like a small thing when freedom of debate is at issue, but it turns out it's a very big thing, as is cost, because it affects choice. What this means is that even setting aside new entrants, people in what used to be a one newspaper town or a two newspaper town who could read a couple of newspapers and maybe subscribe or buy the newsstand a national newspaper like the New York Times or perhaps the Wall Street Journal, now have access to this vast, vast range of media. City newspapers from all over the country, newspapers with a national ambition, such as the Washington Post, let's say, which had never had national physical distribution in any meaningful sense, international news. But on top of that, what I think has has made this choice even greater is related to the cost point, which is that not only is it easier to access traditional material, traditionally available material, it is much easier for people to produce this material. So as a result, we have more access to information than before. Now, I say this to people, many of whom never experienced the other world, the world that I very much remember. I remember we came to America. We were really quite poor, but we had intellectual aspirations. My parents did for us, the kids, and we bought, one of the things they did is they bought an encyclopedia, the Encyclopedia Britannica. It was an important influence in my life because since my parents and I, we have a very close relationship, and we're not a terribly prudish family, but I can't imagine my parents ever talking to my brother and me about sex. So I learned it from the S volume of the Encyclopedia Britannica. Today, I wouldn't have to go to the Encyclopedia Britannica, right, as a 12-year-old to learn about sex, or learn about anything else. Nobody sells encyclopedias anymore. I was asked to write an article on First Amendment, or the essay for the First Amendment for the Encyclopedia Britannica, and they said, but this is the first edition that will never actually be a print edition. And of course I said, well, okay, no big deal. What print? Who writes on dead trees anymore? There once was a world in which to get information about something required you to go to this book, and if you didn't have it or it wasn't complete, it required you to go to the library and maybe ask the reference librarian which books were relevant, and maybe they would interlibrary loan something for you if you needed to. And today, if we don't get the answer in 15 seconds, we curse Google. Well, why didn't you find the right page for me as number 1 page in the results rather than number 3 page in the results? It is shocking how much we have gotten used to this. And yet, I think, looking back at what the world was before, we are indeed in a world that is much more freedom of the press. As somebody pointed out, freedom of the press not just, both in the sense of free speech, free, and free beer, free. That it used to be that free speech was free of government restraints, but it was really quite expensive. Today, it is a lot closer in many ways to being both. So in a sense, what the internet has allowed to happen is the validation of these principles that before had been rather clouded by Liebling's observation, rather clouded by the fact that it was very difficult for people to speak in a way that reaches an audience. Today is much easier. Easier does not mean, of course, it is trivial. It is trivial, among other things, you got to persuade people to actually read you, which I think is reflection of free speech. They are free not to listen, and they often don't. And of course, if you have the money to promote your message or the connections to publicize it by a deal with an established company with an established brand or an established institution like Emory, let's say, it becomes much easier to communicate. But there are many, many stories online of people who really didn't have connections, who really didn't have money, but who built for themselves an audience. And helped add to public debate. So that's a very good thing, I think, on balance. And it has also been increased by a statute which, unfortunately, doesn't have a common name. Some people call it the Communications Decency Act, but that's actually not terribly helpful here because a big part of it that really was focused on decency in the sense of restricting indecent speech was struck down by the court in Reno v. ACLU. We just call it usually Section 230, and that's the statute that said that service providers, and has been interpreted as both service providers in the sense of America Online, if you still remember them, or Emory.edu as providing internet service for people, and other content providers, such as those who run a website like us, or like the Washington Post, or like the Atlanta Journal-Constitution, and provide space for people to comment or to post, that they are not liable, generally speaking, with some exceptions, for the content of the speech that's posted. And that has further increased the amount of choice because it has made it possible for those who provide these services to enable others, even others who might be the targets of libel lawsuits, whether justified or not, to use those services. So put them all together, I think in many ways, this has fulfilled the promise of freedom of the press. But unsurprisingly, it has also yielded some interesting and possibly harmful, certainly harmful in some instances, commentaries. So the internet, as I mentioned, makes it easier. And again, some of this is kind of obvious, but it's sometimes helpful to think back on the obvious things because they were not at all obvious this way 20, 25 years ago or more. So it makes it easier to write and to read what? Dissent from political orthodoxy. That's, again, part of the happy story. It used to be often said by people on the far left, people on the far right, people on, in other areas, environmentalists, libertarians and such, saying, look, you've got a bunch of newspapers, some may have a liberal bias, some have a conservative bias, but none of them are going to run our truly radical messages. Our truly radical messages of revolution, again in either direction, are truly radical messages of libertarianism, of greenism, whatever else. Well, there's certainly plenty of space for that today. Likewise, dissent from media orthodoxy. Many people said, look, it's not even just the politics. It's just that the media are interested in one set of things, maybe because they're shallow or because they're cultural biases. We're talking about completely different things. And we can't get a word in edgewise. Political organizing. We see, both in America and elsewhere, how Twitter, how Facebook, and other internet technologies are being used for actually building political movements on the ground. So the internet is in aid of other forms of speech, just as historically, of course, print had been used in aid of those other forms of speech. But because it's so much cheaper, more convenient, and providing a larger range of opinions, it has made that much more possible. Too, of course, I should add political organizing for good messages as well as for bad messages. Stories written for niche audiences. Technical things on science, on law, and the like, where it wasn't really so much of a prejudice against by the media. The media might just say, look, there's just not enough of an audience for this to justify including it in our newspaper. If only 1,000 of our million readers are going to read this, we can't include that, even if throughout the country as a whole there may be 1 million people who would want to see this. Well, we're not reaching the country as a whole. Today it's easier than ever to have stories written for niche audiences. Breaking news stories identified by specialists, again, science, law, politics, whatever else, can often identify, these specialists can identify problems that the mainstream media wasn't interested or wasn't able to pick up. Stories as such written by specialists. One of the things I love about the blog is I provide this forum for colleagues, and if you want to see the latest commentary on the latest computer search and seizure case, you can read my colleague Oren Kerr, my co-blogger Oren Kerr, who is the country's leading expert on that. You can read his actual views rather than his views as filtered, often incorrectly, by a generalist journalist who then provides a quote or two from him. Of course, it also makes it easier to write and to read libel. Makes it easier to write and read insults. Politically extreme advocacy, well, some people would view as good dissent from political orthodoxy. Others view as bad dissent from political orthodoxy. Maybe sometimes the orthodoxy is right. Maybe this politically extreme advocacy is more evil, more dangerous, more harmful than it is good. Hard to tell. The internet surely doesn't know. Revenge porn is a classic example. We'll get to that before. You know, before it was very hard to do certain kinds of bad things that now it's very easy to do. You could have submitted a piece of revenge porn to the Atlanta Journal-Constitution. Presumably they wouldn't have published it, but the internet will publish anything for you. Prostitution ads is another example that's been coming up. Another example, by the way, of how complicated the good or bad judgment is about this. Some people say, well, this is bad because makes it easier for there to be prostitution, and some of these are ads for underage prostitutes, let's say. On the other hand, some people say, well, there's been prostitution for all of human history, probably, certainly is now. It's better if prostitutes can put up a website rather than have to be on the street and have to pay, face a high risk of violence, have to pay more to pimps and the like. That maybe these kinds of things are a sensible harm reduction strategy. And of course, the indelible foolish comment, the comment that hurts the writer probably much more than than its subjects. But then whenever somebody Googles this person's name for eternity and for the rest of this person's professional life, they'll see this foolish, foolish thing. That's a bad thing too in a certain way. That's something was a lot harder to do because sometimes the editors of the newspaper would save you, the letter writer, from your foolishness by not publishing your letter. And you'd say, I am being censored, and in a certain definition of censored you were being. Maybe you should have counted your blessings. Well, there are no such blessings anymore. Now, of course, this is not news. Some degree of abuse is inseparable from the proper use of everything, and in no instance is this more true than in that of the press. James Madison, in the technologically advanced time of 1798, we should never forget, by the way, that the press itself was understood at the time of the framing as a technological advance. It was often praised as a technological advance. The framers were well aware of technological change. And they saw that the press amplifies the good as well as the bad. Well, the internet just amplifies both even more. So what happens with that? What do we do when there is this bad speech as well as the good speech? What have been the legal reactions? Let me mention a few. Some of which I don't like, some of which I think are acceptable. But my claim in this talk is simply that this is what free speech has done, what cheap speech has done. What has happened is that because there's been this greater amount of choice for readers, greater ease of communicating for writers, there have been there have been great increases in certain categories of speech that before, as an artifact of the very flawed regime of the press belonging, freedom of the press belonging only to those who own one, that before had just not come up, at least not come up as much. So here's one example, criminal harassment and cyber-stalking persecutions. The dean mentioned that I'd been doing some litigation recently, and I had the privilege and pleasure of arguing a case in front of the Georgia Supreme Court just last fall. And the case, which is still pending, involved a website. The website was called Extortion Letter Info. And the website was aimed at criticizing people who, in the website authors' viewpoints, were writing copyright extortion letters. It originated when a company called Getty Images started sending demand letters for those who posted copyright infringing material. And the claim of the website operators is whether those letters were or were not well-founded. They were illegally well-founded. They were unethical and should be criticized because they basically took advantage of the fact that many people who posted things that maybe were fair use, maybe weren't in a position to defend their fair use claims. And if they were sent a letter demanding $5,000, which the view was this was a ridiculously high amount, they may settle rather than having to pay $10,000 just to a lawyer just to look at their case. Well, there was a poet named Linda Ellis who wrote this poem about death and about how we want to be remembered after death. And it really struck a chord with many people, including many people who are grieving the loss of their loved ones. So many people posted it on their websites. And she started sending them letters demanding thousands of dollars. Well, the extortion letter info people were quite upset with her about this and posted both the operator and, now remember Section 230, he allowed him to have a large community of commenters, posted all of these things that were harshly critical of Linda Ellis, including several posts that could arguably be seen as personal threats, although I'm really quite skeptical of that. I'm not Chan's lawyer. I participate in the case as a lawyer for Amici, Electronic Frontier Foundation, and a law professor. But I do think, even though I am kind of biased in this, that there weren't threats. But even if they were threats, what was the remedy that happened? What happened was, and this actually fits into to a related thing, which is restraining orders, is that the trial court ordered the website to take down all posts that mention Linda Ellis. There are many hundreds of such posts. Most of them were probably critical. Probably not even all of them were critical. It wasn't in order to take down these 5 posts that were arguably threatening, and it's again not clear to me that they were. But even if they were, that might justify an order to take down those 5 posts. This is an order to take down all of them. Now, it's being challenged right now before the Georgia Supreme Court. I very much hope the Georgia Supreme Court sets it aside. The interesting thing, though, of course, is that while these orders theoretically were possible back before the internet, they were not very common, a lot less common than they're becoming now. Dean Erwin Chemerinsky is in the audience. He litigated a case called Torrey v. Cochran, in which Ulysses Torrey was picketing outside Johnny Cochran's office. And Cochran was claiming Torrey was just trying to extort money from him. But Torrey was saying, you know, Cochran has done all these bad things. I want to inform the public about it. Case went up to the U.S. Supreme Court, but Johnny Cochran died during the pendency of the case. So as a result, the case from a broad question about when assertedly libelous speech could be enjoined became a very narrow question. So we don't have much of a clear view on that. But even that was a case where the court said, well, you know, we think this speech is libelous. That's why we're enjoining it. In this case, there wasn't even a finding that all of these statements that were being enjoined were libelous or threatening or anything else. But what I think is happening is that courts are seeing, look, before, if somebody writes an article critical of Linda Ellis, maybe the newspaper will run one or a few, but they're not going to run hundreds. They're going to only choose to run those that they, in their respected editorial judgment, think are fair. You know, maybe people will read it and then forget about it. But now, here are all of these things constantly being posted about there. Google her name, you're going to see all of this stuff. This is too much. This is, in the lay sense of the term, harassment, says the judge. And as a result, these things are stepping in to respond to this extra freedom of the press that many people are finding quite troubling. I understand why they're find it quite troubling. I think the remedy here is not at all the right remedy, but I do think that this is happening, that these kinds of orders are being put into place in large part precisely because the internet really makes real for the first time the notion of freedom of the press. Let me mention a couple of other examples. So restraining orders, the injunctive version, criminal harassment and cyberstalking prosecutions are the criminal punishment version. So one is in the city of Renton, which you may know from the Renton v. Playtime Theater's so-called erogenous zoning case from the 1980s. Well, the city of Renton is back, or was back, although not at the Supreme Court. There was somebody who had posted a YouTube video mocking the Renton Police Department and referring, without naming names, but in a way that people who were in the know understood whom he was referring to some supposed sexual shenanigans. Nothing criminal, but sexual shenanigans like people having sex in police cars and so on and so forth. Well, Washington criminal harassment law, bars, I'm working from memory here now, but bars use of lewd comments in a way intended to abuse, offend, or harass a particular person. Historically, that's involved speech to a person. Somebody calls you up and says lewd things to you on the phone. But courts have now, I think in part because of the internet, begun to interpret this as covering also speech about a person. What happened was the police department just wanted to figure out who this guy, Mr. Fuddlesticks was the name he used, who this guy was, because I think they suspected he may have been an employee or somebody like that. They would have had some way of retaliating against him. So they got a subpoena against YouTube, ordering it to turn over information about who this person was. And why? What's the basis for the subpoena? Well, violation of this criminal harassment statute. Ultimately was quashed in large part because there was a big public outcry largely on the internet about this. But again, before the internet, this wouldn't have happened because any such video would either not have been ever aired on a television station, or if it was aired on a television station, perhaps cable television, which wasn't subject to the indecency rules the way broadcast television was, I think a judge would have been quite hesitant to order that the television station disclose who submitted the video, because he understands, oh, that's a free press issue. But here, this is something that's new enough, at the same time seems dangerous enough to many judges, that these kinds of subpoenas could at least at first be enforced. There are other examples. There's a case called U.S. v. Cassidy, which involved the persecution of somebody. This was a man who went to a Buddhist monastery in Maryland. The Buddhist monastery that is run by which the head head religious figure is a woman, actually a former, I think, Brooklyn housewife who discovered Tibetan Buddhism, and I believe is the highest ranked woman religious figure within this stream of Tibetan Buddhism. So he apparently ingratiated himself to them. He said he had was dying of cancer. He offered his services as a financial advisor, became the CFO of this monastery, then was kicked out, possibly because of financial improprieties or because some of his lies were found out, although apparently the official statement from the monastery was that they came to doubt his reincarnation credentials. And then he started tweeting hundreds of posts. Again, a few possibly threatening, but probably not. A few various such posts harshly criticizing this woman. So think of it as Hustler v. Falwell on a somewhat smaller scale and a very different religious figure, but all online by somebody who doesn't have a reputation as a member of the media, however disliked that media may be among many. And the federal prosecutor prosecuted this guy for these tweets on the grounds this was cyber stalking, that this was a pattern of harassment that inflicted severe emotional distress on this woman, which it probably did. And the judge ultimately threw that out on First Amendment grounds. So I don't think that I think these things are being constrained on First Amendment grounds now, but I think the very fact that there is this pressure for these kinds of orders and these kinds of persecution is a reaction to the fact that free speech is now free in both senses of the word. We see new cyberbullying statutes and ordinances being implemented. I'll mention some later. Criminal libel prosecutions. Criminal libel was long thought to be dead. Turns out it's not. There's a fascinating article by David Pritchard, who's at the University of Wisconsin Communications Department, reporting on libel law, criminal libel law in Wisconsin. And it turns out that even though there are very few reported cases in the sense of appellate cases, there are trial-level criminal libel prosecutions to the tune of about 5 or so a year happening in Wisconsin. And he actually says it's a good thing. They're not generally about politics. They're people who are saying lies about their neighbors in order to get revenge against them or to otherwise trouble them. And the penalties are modest, but they kind of reflect the judgment of the community that this is intolerable behavior. Interestingly, he says that as a result of the internet, these kinds of things have about doubled in Wisconsin. Because if you are libeled by a newspaper, that's not something you'd want to have happen to you. It would be a very expensive case to bring, but at least if you have a very strong case, you know there's somebody out there with the money, and maybe you can find a lawyer who will take it on a contingency fee. You can't do that with when some schmo in town who has no money is posting nasty things about you. You turn to the prosecutor's office. Revenge porn bans, again, I'd mentioned this before. I think it's properly crafted. I think they may very well be constitutional. I think they would be constitutional. But again, this is a 21st century solution to a 21st century problem, a problem that the limited free press regime of the past essentially made extremely unlikely. Calls to modify this immunity for service providers are often tied into that. Likewise, in California, there is a law actually requiring a website operator to remove reader comments at the reader's request if the reader is a minor. The theory is to deal with the "your foolish posts will live on forever" problem. Query whether that's permissible. Let me give you an example of one of these cyberbullying statutes, because I think it shows how sometimes these reactions to changes are misplaced reactions. Nonetheless, they're there, and they happen. This is a statute that was struck down very recently by New York's highest courts. It bans any act of communicating, so it's not just the internet, but it's pretty clear that the county board of supervisors that enacted this had the internet in mind. It specifically mentions this. That consists of disseminating sexually explicit or embarrassing photographs. Note how often there's a nubbin of stuff that people say, oh, yeah, there's got to be some way of restricting. But it's surrounded by other stuff that is considerably broader. Disseminating, again, sexual, false, or private or personal information about someone, or sending hate mail, no definition of the term, with no legitimate private, personal, or public purpose, with the intent to, again, possibly threaten, well, that could be punishable, but also torment, humiliate, or otherwise inflict significant emotional harm. New York Court of Appeals, again, New York's highest court, struck it down, I think quite rightly. Among other things, this means that if somebody were to post on their Facebook page, oh, my status is now single because my horrible ex-boyfriend cheated on me, well, that's disseminating, I'm sorry, not photographs, but disseminating private, personal, and sexual, even if completely true information. And then it would be up to the jury to decide whether this was a legitimate private purpose or not. And whether there was an intent to torment or humiliate. Maybe there is an intent to torment or humiliate when people reveal other people's misconduct. And among other things, the court concluded that you can't really put free speech at the mercy of government officials or jurors deciding whether the purpose is legitimate or not, at least at that level of generality. So that's some of the legal reactions to the internet, some of the attempts to restrict some of the assertedly bad, and often indeed bad, but sometimes not so bad, see the Renton case, and depending on how you view it, the Cassidy case, speech that cheap speech has allowed. But there are some other legal consequences. One is the famous Streisand effect, and it comes from Barbara Streisand, who had this multi-million is a funny thing to say in LA. Everybody's home almost is multi-million on the West Side. Multi-million. I have the vague sense of 10 or 15 million, but maybe I'm off by some number in either direction. This beautiful home alongside the beach. There was an aerial photographer that was photographing everybody's homes. He posts this. So she says, this is an invasion of my privacy. I don't think this actually is, as a legal matter. She sends him a demand letter. The demand letter hits the internet. Now everybody is talking about the story and posting the picture. And, everybody has a good laugh. Barbara Streisand gets what's coming to her. Nobody's that sympathetic with people who own $15 million homes, who are so upset, oh my God, somebody's looking at it. But this is actually a pretty real problem, right? Imagine you have a very good, solid invasion of privacy case, or a good, solid libel case. If you bring it, what will happen is people will start talking about it. The invasion of privacy will only be magnified by talk of this story. And if it's a libel case, then people in the process of talking about the lawsuit will talk about the allegation. And some people may remember the denial, others will remember only the allegation. It always used to be a problem in some measure, but sometimes the newspapers would kind of fudge out some of the facts to diminish the exacerbation of the invasion of privacy. Not so much on the internet. So this is a plus. It tends to deter bad libel and invasion of privacy lawsuits, but it also tends to deter good ones. Again, use and abuse are inseparable with the press and with the internet. Here's another example. There is a case that came up just a couple of months ago in Connecticut. What happened is a Connecticut family court judge ordered that a particular petition it was denominated petition for habeas corpus, but essentially a family court petition, that had been published in open court be sealed in order to prevent the children from eventually reading about it, or even soon reading about it, and being traumatized by all of this talk about the parents' contentious divorce. It wasn't because there was specific personal medical information or such that wanted to be redacted, wanted to block the distribution of the entire thing. And in the process ordered the Connecticut Law Tribune, a newspaper, a legal newspaper in Connecticut, to not publish it. And I think it had it on its website, to take it down from its website. So of course they went to court, tried to get it vacated. This was around Thanksgiving, there was a bit of a delay. I got an email, I'm sure other people got an email. Somebody pointed me to the petition, so I posted it on my blog, which happens to be hosted in the Washington Post. So now it's on the Washington Post's website. Why did I do that? Well, that's what I do. I write about free speech issues, and one of the things that I write about one of the things that I try to do is I try to link to original documents so people see what the fuss is all about. So I did it. I felt no compunction about it. I certainly wasn't subject of an order. If I was, I would have challenged it, because that's, I think, what one ought to do, especially as a lawyer, is not to just ignore the order, but to challenge it. But I wasn't bound by the order, so I posted it. So several days later, the order gets vacated, because apparently some other sites had posted it too, including some other mainstream media site, but I don't know which one. And the judge says, well, look, I still think I was right to issue this injunction, But one of the things you have to ask when you're issuing an injunction is whether it will accomplish the result that is being sought to be accomplished. This injunction can't do it anymore because the cat's out of the bag. The various websites, including 2 mainstream media sources, have published it, so now it's futile, and that's it. Connecticut Supreme Court eventually concludes the issue, therefore, is moot because the injunction is resolved. Well, again, before the internet, this could have happened. In fact, those who followed case law from the 70s know this is pretty much what happened in the progressive H-bomb case, right? There was an injunction against publication of an article in the Progressive magazine about how H-bombs can be built. That was appealed to the Seventh Circuit. Seventh Circuit was considering it. And then what happened is a newspaper in Wisconsin that was actually being run by striking newspaper workers, it was sort of an alternative newspaper being run by striking newspaper workers, republished the whole thing. And the Court of Appeal said this injunction is going to be vacated because the cat's now out of the bag. Although, in fact, actually, Progressive said the cat was out of the bag a long time ago. This isn't really that secret information. But in any event, this cat out of the bag theory is out there. It's just much more likely to be invoked when anybody can let the cat out of the bag. It used to be only a few people who owned printing presses who could let the cat out of the bag. Now everybody can just peel it away. So, So the third thing, which is less talked about, but I think is just as important, is the Hitman effect. So this is Hitman, a technical manual for independent contractors, which purported to explain how to be a contract killer. It was written by Rex Ferrell, which is a pen name, as you might gather. It was published by Paladin Press. Somebody actually used the information in this to kill a couple of people. The decedent sued Paladin Press. And the Fourth Circuit held that because they alleged that Paladin Press published this with the purpose of promoting crime, that allegation can go forward. And once that happened, the insurers pressured Paladin Press into settling. Purpose was really important here. Because everybody, I think, agrees, or everybody, not everybody in this room necessarily, but I think pretty much all courts would agree that you can't ban the publication of a novel that talks about a crime just because there's recklessness that people might use that information to commit a crime. I think there was Day of the Falcon, maybe, one of the big thriller novels, had information about how to, in England, essentially come up with a fake identity that was then routinely used by people until that legal loophole was closed. Nobody would allow liability for that, or for that matter, a chemistry textbook that describes how bombs are made. But purpose is a different story, the theory goes, the Fourth Circuit said. And then the Department of Justice picked that up. Congress picked that up, and now there's a federal law that bans the publication of bomb-making information, specifically bomb-making, if you have this bad purpose of promoting bomb-making. Now, one can debate whether or not that's a good idea. I think it's not. I think purpose tests are actually not generally sound in First Amendment law for various reasons, which I won't bore you with. But there's one in particular which ends up being kind of internet sensitive. And that reflects the following. So we have purpose-based liability for publication that actually led to punishment, maybe you might say justice, against the publisher. The publisher had to pay, although the insurer had to pay. The victims were compensated. What was the consequence? The consequence is if you search for Hitman, Manual for Independent Contractors, you will find several copies, with very little difficulty, of the entire book posted online. It used to be that if somebody wanted to use this to commit contract killing and query how much it would actually help him, but let's assume that it did, let's assume it was dangerous in that respect, he had to go to a bookstore or more likely send away to Paladin Press. That would be costly for him. It would be inconvenient for him. It would leave possible records that would allow him to be found. But now that this dangerous book has been taken off bookstore shelves, it is now available in the span of seconds for free to anybody in a way that's much less easily traceable than a mail order from a bookstore. So the consequence is that purpose-based liability for publication leads to punishment from a publisher, but no interference with access. because mirror copies are put up by people without the culpable purpose. It's not like if you go up there, you'll find it on all of these pro-contract killing websites. No, these are people who, whether rightly or wrongly, think of themselves as free speech warriors. They put this stuff up precisely in order to fight censorship and also to, again, help people understand what the fuss is all about. It's a lot easier to understand the case if you actually can see the book. But the consequence is that there's actually no interference with access. There's greater ease of access. Rightly or wrongly, that's one of the things that cheap speech has built. Let me close with one other example, freedom of the press. It's long been a question whether freedom of the press is industry, freedom of the media professions and media businesses to do certain things, or it's freedom of the press is technology, freedom of all of us to use the printing press and its technological heirs. Justice Stevens recently in Citizens United weighed in on behalf of 4 justices on the freedom of the press as industry side. He says, look, the majority says, look, if we ban corporate speech, or if we, allow restrictions, allow bans on corporate speech about certain topics, that means that the government could ban newspapers from doing that. That can't be right, because most newspapers are corporate owned. Stevens said, no, it's okay to uphold bans on business, non-media corporations speaking, because media corporations are protected by the Free Press Clause, because they are the press. Now, I wrote an article about it. It turns out that from basically the late 1700s up until 1970, everybody took the freedom of the press as technology perspective. No court adopted Justice Stevens' view. Since 1970, there had been some mutterings in the Supreme Court and some holdings, minority holdings of lower courts that do take the Stevens perspective, but still it was very, very much a minority view. But one of the consequences of this new world is it becomes very, very difficult, even if you thought that the right approach is the Stevens approach, to decide who's the press and who's not. It used to be pretty clear, do you own a printing press? And only a few people did. Now it's pretty much everybody. And that's actually one reason why some courts recently have rejected this kind of approach, although again I think the Stevens approach should be rejected on other historical and normative grounds too. This is not something, though, that can easily be done with regard to statutes that provide extra protection. Journalist privilege, libel retraction statutes, campaign finance laws. I recently litigated a case, I can't move back there, having to do with interlocutory appeal in media cases under a Texas statute. Those are statutes that go beyond First Amendment protection and do seem to single out the media, the press's industry for special protection. But it's not clear how that will actually survive, just as an interpretive matter, given how hard it is to tell the difference between magazine, periodicals, and a typical website. So let me close. Freedom of the press is freer than ever. It's more compatible with free press rhetoric than ever. In fact, in some respects, it's the vindication of all this free press rhetoric that had before been much undermined by the Liebling insight. It is better than ever, and it is worse than ever. So with that, I close, and I think we have at least a few minutes for questions.
Eugene, I found your talk to be really, really interesting. A couple of things that I thought you might consider is the funneling of particular speech by Google and others. This thing that just recently was written about in the filter bubble, where the commercial entities and Google are able to funnel certain speech and to put them as the primary finds, as well as limiting individual searches based on, invisibly limiting individual searches based on the cookies that have been placed on the machine. And therefore, in that way, the internet is a limitation on speech, at least in the direction that it's headed in the commercial world, in a way that's invisible to the common user. The other thing I wanted to ask you about on a different topic is the very important point you made at the very end, which is about press. I mean, if you say that now it's so difficult to identify the distinction between press and other corporation, doesn't that read the press clause out of the Constitution? I mean, isn't that the real key here between, say, Citizens United and New York Times or whatever press? There's always been a difficulty of identifying issues about corporations piercing the corporate veil. You know?
So a couple of questions, a couple of responses. One is this whole question of search engine search results in the free speech is something I wrote about. It was a white paper, it was a commission white paper. I wrote it in my capacity as an advocate, so I'm hesitant often to talk about it in much detail as a scholar. As a general matter, I think there is a potential problem if search engines end up restricting the results. In a sense, that's kind of like the New York Times being able to restrict what's published, but more so because more people use them. At the same time also, if you don't like what your local newspaper in one newspaper town was saying, there was very little that somebody else could do to give you another option. But most people who use Google use something else before. They switched to Google, and they switched very quickly. I switched from Alta Vista. And they can easily switch away. So I think that is an area where, in fact, competition is, if there are real problems with Google, and I'm not sure there are, competition would be, I think, a pretty powerful force. As to the freedom of the press, if you look, and I wrote an article about this actually 3 years ago now, it's in the Penn Law Review, if you look at how the freedom of the press was understood from the 1770s on, it was almost invariably understood as the freedom of everybody to use printing technology. It doesn't read it out of the Constitution. It makes clear that mass communications technology is as protected as speech in the traditional sense, which is talking to somebody. It wasn't at all clear around the time of the framing. Many people said, oh, well, of course people can speak, but this new printing press technology, that could destroy nations, that could destroy governments. It has toppled governments. That's something that should be regulable. The Freedom of the Press Clause says it's not regulable, at least not regulable perhaps outside of certain narrow zones, or you can debate about prior restraints or not, but in any event, it provides protection for mass communication technology. Today we might see that it is redundant because freedom of speech, today we talk about a newspaper as an exercise of speech rights. But the only reason we say that is there is the Free Press Clause. The Free Press Clause and the Free Speech Clause have evolved over the last 200 years to essentially cover this broad range, and I think for very good reason, broad range of expression. If there hadn't been a Free Press Clause, then I don't think Free Speech Clause would be seen as broad as it is today. So I don't think this at all makes Free Press Clause redundant. And if you look, as I said, for examples of the Supreme Court or lower courts actually treating the freedom of the press as providing any special protection to particular media, you will find, at least I found, not a single one until about 1970, at which point we began to see a smattering of them and very much a minority view both among lower courts and among dicta from the US Supreme Court. So, no, it doesn't read the Free Press Clause out of the Constitution. Free Press Clause says mass communication technology is protected, a tremendously important thing, especially viewed through the lens of 1791. It just doesn't provide any extra protection to any particular users of that technology. Do we have time for one more question?
I'd like for you to comment about what went on in Paris with the shooting at the magazine. People kept saying, "Je suis Charlie," and that was lauded. Then somebody started to say, "Je suis" in the name of one of the shooters. And that person went to jail or certainly got in trouble with the French authorities. I was wondering what you thought about that.
I'm glad I live in America. I do not support French restrictions on extremist speech, or in this kind of situation, I believe the law under which this is a prominent comedian in France, apparently a very bad man, but I think ought to be protected by freedom of the press. Dudon is his last name. But there's a law that essentially bans, I think, either glorifying or expressing agreement with terrorists. And I oppose that. And I think quite rightly American law protects that. It protected it before the internet, and it protects it today. Now, today it's a lot easier to communicate these things to a wide audience because it used to be you had to persuade some publication to run them, and most publications, from a combination of business pressures and kind of personal moral judgment, refused. Now there is a lot more of this stuff online. I think it should be constitutionally protected. But for purposes of this talk, it's simply the observation is simply that there is more of the bad stuff as well as the good stuff. And there are attempts to try to suppress the bad stuff that before might have been seen as unnecessary because this limitation, the economic limitation of freedom of the press, did a good job of suppressing the bad, as well as suppressing much of the good. Now that limitation is no longer there. Now at least people are starting to talk more. They've always talked some about it, but starting to talk more about trying to suppress the bad. Apparently in Europe, that's happening, both as to the bad and as to the good. In America, fortunately, it hasn't been.